All right, Miss Fortuna Gill, how are you? And what are we calling first today? And you're working out the Murphy, the logistics on the Murphy case?
Yeah,
Or the timing, I should say, of the Murphy case.
that is a bit of a pickle.
Yeah.
One of the final pre-trials is law enforcement, so we could probably do that, but it doesn't change the fact that there's another
Yeah,
one.
it sounds like they're gonna run a prelim and we'll do it after the prelim.
Yeah,
But if they don't run a prelim, then we'll just do it when we can.
we'll see what
How's
happens.
that?
Yeah, sounds good. As for if I need to know who
All right,
we have
there's somebody from the Post. I would think that's Wilkinson. Miss Rothstein's on, or
Yes.
Mr. Allerid.
Yes, sir.
Jonathan Allerid is here for his 9 o'clock. Mr. Quicks is here. Wicks.
Yep.
For his 8:30.
Okay.
Keith. I don't know who Keith is.
Rembert, yeah, Keith Rembert.
Keith Rembert. Okay, let me rename him. Do you want to?
Yeah.
Okay. So Rembert is here for
his. Should be ready on Mr. Bregman's matter.
Bregman.
I'll need a breakout room with Mr. Wicks and Mr.
That's correct, John.
All right. So you're ready on Bregman, and Miss Robinson, you'll need a breakout room with
Mr. Wicks and Mr. Allred, please.
Okay.
Thank you.
So Mr. Wicks, I'm going to place you in room 1, and then your public defender should be in the CU. And Mr. Allered, I'm going to place you in room 2, and your public defender should be in the CU. And then when Miss Robinson joins us, I'll put her in, and then we're ready to go on Bregman.
Yes.
From the Abood Law Firm, Mr.
Anderson.
All right, let's go on Bregman. All right, so we're on the record in docket 2601352. That is People of the State of Michigan versus Edward Bregman. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Anderson.
Morning, Your Honor. Michael Anderson on behalf of Mr. Bregman, who appears via Zoom.
And sir, you are Edward Bregman. You'll have to unmute.
Yes.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. At this time, we're asking that the matter be left set for preliminary examination. An offer has been extended to plea to count 3 and an additional count 4 of misdemeanor domestic violence 93-day with the dismissal of counts 1 and counts 2. That offer will remain open until the beginning of the preliminary examination next week.
Right. Mr. Anderson, is that a fair statement? We're going to leave on for prelim on June 5th at 8:30.
That's correct, Your Honor.
All right. All right. So we're leaving on for the previously scheduled prelim for June 5th, 2026 at 8:30. That would be next week at Friday at 8:30. And the terms in the offer have been placed on the record. Anything else for the record in 2601352, Ms. Fortuna Gill?
Not for the people.
Mr. Anderson.
Just confirming for my client, Your Honor, that is in person.
That is in person. So it'll be live in person on the 6th floor of City Hall of Lansing. All right, Mr. Bregman?
Yes.
All right, we'll see you there. We'll see you here at 8:30. Thank you for your appearance today. You're all set, Mr. Bregman.
Thank you, Judge.
Yep. Have a good one. Have a good weekend.
We'll see you, Mr. Anderson.
See you, Judge. Thank you. Have a good weekend.
We are ready on Rembert.
Rembert. Keith Rembert.
There's going to be one I need to consult. Don't worry.
Oh, let me move Miss Robinson. So, Miss Robinson, I'm going to put you in with Mr. Wicks, and when you're done there, you come back, and I'll put you in with Mr. Allered.
Thank you.
Let's go. All right, so we're on the record in docket 26013441. That's people of the state of Michigan versus Keith Rembert Jr. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Doyle.
Yes, good morning, Your Honor. Dan Doyle, appearing on behalf of Mr. Rembert Jr. Just for the record, I'm standing in for the attorney of record, Michael Oakes.
Michael Oakes. All right. Thank you. And sir, you are Keith Rembert, is that correct? You'll have to either get closer to the mic because I can't hear you.
Yes, sir.
Okay, perfect. And you can hear me all right, Mr. Rembert?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. At this time, we're asking that the matter be left set for preliminary examination.
And is that a fair statement, Mr. Doyle?
It is, Your Honor. It's a fair and accurate statement, Your Honor. We did request some additional discovery, but besides that, I want to leave it set.
All right. So we are leaving on for prelim next Friday at 8:30. So Mr. Rembert, that prelim will be live in person on the 6th floor of City Hall of Lansing. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 26013441, Ms. Fortuna Gill?
Not for the people.
Mr. Doyle on behalf of Mr. Oakes.
No, Your Honor, thank you.
All right. Mr. Rembert, you're all set. Thank you for your appearance today.
All right. Thank you, Judge.
And I'm going to go on. I don't know.
Do you want to go on Brandis? Are you ready?
Yeah.
We can go on Brandis. Right, because we need the PSI.
Oh, yeah.
All right, so we're on the record in docket 2501751. That is people of the state of Michigan versus Lee Brandis. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Lee Brandis, who is standing to my right. Mr. Brandis, if you can please state your first and last name for the record.
Lee Aaron Brandis.
All right, thank you. This is the time set for a sentencing in the matter. The last I have on this matter is that Mr. Brandis was failed to appear on August 18th, 2025. And then it was rescheduled for August 29th, 2025. So we don't have a PSI.
Yes,
Is
Your
that
Honor, if I
your
may.
statement? You may.
So my understanding is that is correct. There was the initial failure to appear for the PSI and for sentencing, at which point he was put in bench warrant status, I believe on I believe it was actually December 9th, and was in bench warrant status until he was picked up, I believe, on or around early to mid-April, and arraigned on the bench warrant, at which point he was, I believe, remanded for the PSI to be completed. I did end up speaking with him via Polycom from the jail. I went over that process with him, how and what was likely to happen. However, according to the probation department, who I just spoke with downstairs, it sounds like probation was never notified that he had been picked up or was in custody. So they were still under the impression he was in warrant status, and therefore never did an updated PSI until today, when Mr. Brandis showed up for his sentencing hearing after automatically PRing after 14 days.
So
And
what's his bond right now after 14 days?
I believe
Is it
I
PR
believe
bond?
it would just automatically converted from the no bond to a
Okay.
PR bond, because the sentencing hearing was set out more than 14 days, and the no bond hold was essentially to try and get the PSI done, which unfortunately didn't happen.
So I see how this happened. And yet, Mr. Brandis, this is actually a good time because probation's covering everything right now. Every court officer. You had some fail to appears, and that's why you've had a previous fail to appear out of July 15th, out of October 2025, July 2025, and December of 2025. So I would think that on today's date, Mr. Brandis should probably get an appointment with probation.
That would be my request.
Yeah,
Your
and
Honor.
then And we'll keep you on your bond status, on your
Appreciate
PR
that.
bond status.
Mr. Flores.
Yeah, I think that's probably the way to go here. And then and then we'll just reset it for sentencing once. I think they can do a PSI probably in about 6 weeks, 4 to 6 weeks.
Yeah, so I would request that the court would consider resetting sentencing, and then I
Yeah.
can bring Mr. Brandis downstairs to get that appointment.
All right, so let's reset the sentencing. Or let's do the 6th, 4th, full, just so probation can catch up.
So let's do July 10th at 10.
July 10th at 10 o'clock. So I think the probation department, if you go see them now, they'll set up an appointment to see you, and then they can do the PSI.
Thank you.
Okay. And then we'll do the sentencing on July 10th at 10 a.m. Anything else for the record in 2501751, Ms. Fortuna Gill?
Not for the people, Your Honor.
Mr. Harris.
From the defense, Your Honor.
All right, Mr. Brandis, you're all set. Thank you for your appearance. All right, Ms. Robinson, I'm going to put you in room 2 now, okay?
Thank you.
Rothstein.
Yes,
All right.
she is present on Zoom.
All right, Ms. Rothstein, you can unmute. We'll call that case. Mr. Lara, you can unmute. So we're on the record in docket 2601381. That is the people of the state of Michigan versus Guadalupe Laura. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Rothstein.
It's Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Lara, who is appearing via Zoom.
And sir, you are Guadalupe Laura, is that correct?
Yes, that's correct.
And you can hear me all right, Mr. Lara?
Yes.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. At this time, we're asking that the matter be left set for preliminary examination. At this time, there is no offer to place on the record. However, I do anticipate there may be one. I will be in continued contact with Ms. Rothstein about that matter.
All right, Ms. Rothstein, is that a fair statement? We are going to leave on for preliminary examination for June 5th at 8:30.
Yes, Your Honor, it is.
All right. So, Mr. Lara, that'll be live in person on the 6th floor of City Hall of Lansing on June 5th at 8:30. We'll do the preliminary examination, or that's when the next preliminary examination is scheduled. It'll be next Friday at 8:30. Anything else for the record in docket 2601381, Ms. Fortuna Gill?
Not for the people.
Ms. Rothstein.
No, Your Honor, thank you.
All right, Mr. Lara, we'll see you next week at 8:30. Thank you for your appearance today.
Thank you.
Is Mr. Wilkinson present?
Yes.
Oh, we are ready on that matter. Ms. Rothstein is covering for Mr. Silverthorne.
All right. All right, so Ms. Rothstein, you're ready on Mr. Wilkinson?
Yes, Your Honor.
All right. All right, so we're on the record in docket 2601382. They have a new register of action sheet on that. That is people of the state of Michigan versus William Wilkinson. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Rothstein.
Yes, good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing for Mr. Silverthorne on behalf of Mr. Wilkinson, who is appearing via Zoom from the Ingham County Jail.
And sir, you are William Wilkinson, is that correct?
Yes, sir.
And you can hear me all right, Mr. Wilkinson?
Yes, sir.
Right, thank you. this is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor, at this time, we're asking that the matter be left set for preliminary examination. There is an offer of a 1-year misdemeanor MDOP. I will be in contact with Mr. Silverthorne about that further. That offer will remain open till the beginning of the preliminary exam. But I do anticipate it being left on.
All right. So is that your understanding, Ms. Rothstein? We're leaving this on for preliminary examination on June 5th, 2026 at 9 a.m. That's a week from today at 9 a.m. That'll be live in person on the 6th floor of City Hall of Lansing. Is that your understanding?
Yes, that's my understanding upon speaking with Mr. Silverthorne. He also advised that he would be going to the jail to speak with Mr. Wilkerson later today.
All right. All right. So we will leave on for prelim at 9 o'clock next Friday, June 5th. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in docket 2601382, Ms. Fortuna Gill?
Not for the people.
Ms. Rothstein?
No, Your Honor, thank you.
All right, Mr. Wilkinson, you're all set. Thank you for your appearance today.
Well, so
Ms. Wanji, did you want to go on Mr. Payne at 9?
Yes, Your Honor.
All right, so you can come up here, Mr. Payne. All right, so we are on the record in docket 2600446. That is People of the State of Michigan versus Yulee Payne. Appearances for the record, Ms. Fortuna Gill.
Yulee Fortuna Gill on behalf of the people.
Ms. Wanji.
Melanie Biwanji for Mr. Payne, who's appearing in person.
And sir, you are Yulee Payne, is that correct?
Yes, sir.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding? Would you like to defer to Ms. Wanji?
Your Honor, at this time, we're asking that the matter be left set for preliminary examination. There has been no offer extended. I do not anticipate there will be one.
All right. And is that your understanding, Ms. Wanji? We're going to just leave this on for prelim.
Your Honor, we have requested a competency evaluation for Mr. Payne. We have been waiting for that. I have not heard from the forensic yet, but an order had been signed since a few weeks ago.
Yeah, I think, let's see. Well, the petition. And the order was signed on March 19th. And then we have not heard anything from for the Center for Forensic Evaluation. That was signed last week. All right. So let's leave on for prelim, and then if we have to do a good cause adjournment, we'll see what happens in the interim. Maybe they'll do the interview, but I have this. I have the, oh, that's March 19th. I don't know what that in between. So I don't know. We've got they have a week to do the interview,
Right.
because they did file. Ms. Wanji's correct. They did file a packet. I did sign it last week. We can either leave on and then adjourn for good cause on that date. I don't, it just depends on whether they're able to do the interview in a week. I don't believe so.
You know, I have not, sorry, I have not
Go ahead.
received any letter from the forensic setting up an appointment so that I would let my client know about that.
What date is that appointment?
I haven't received any appointment.
Oh, all right. Well, let's leave on for prelim and then we'll adjourn for good cause. And if once you get the date for the interview, but we'll leave on for prelim just to keep it scheduled. Because we have no date for, we have a date for the. So this has been set for prelim before.
Yes.
And this is set for PCC on today's date. So we haven't set a new prelim date.
We have
I
not.
don't-
All right. And we don't want this to fall through the cracks.
Can we just set a review date then?
Yeah, I think what we'll do is we'll set a review date. I think that's a good idea. Or PCC, we'll reset it for PCC, and let Ms. Wanji contact Mr. Payne when an interview is set up. But let's do a review date. Let's do a so we're adjourning as for good cause again. He's waiting to be seen. So the order was signed on, I believe, March 19th, May 19th. Let's see. March 19th. All right, let's set it for 30 days out for forensic review. And if we haven't heard a date for the actual evaluation, we will call forensics and see that they get a move on this, because this is I think we're going on a couple months. So does that make sense, Ms. Wanji? Is that if we don't have at least an evaluation or an interview for evaluation done by forensic by the 30-day period, then we'll contact them and see what's going on.
Okay, Your Honor, thank you.
All right. All right. So I'm going to reset for forensic review.
June 26th.
June 26th at 10. So we're going to reset for June 26th at 10 o'clock. Ms. Wanji will be in touch with you if we get a forensic evaluation. If we do the review beforehand, they're going to interview you. They're going to interview Mr. Payne at your office. Is that correct, Ms. Wanji?
Yes, Your Honor.
All right. So you'll hear from you when the interview time is scheduled and set up. Okay, right, sir? All right. Anything else? And then so we're going to come back on June 26th at 10 a.m. for a control date, just to see what's going on with the case. Anything else for the record in docket 2600446? This is adjourned for good cause, and we've reset it for June 26th at 10 o'clock for review. Hopefully, Mr. Payne is interviewed in the interview by the Forensic Center. Anything else, Ms. Fortunico?
Nothing for the people, Your Honor.
Ms. Wanji?
Nothing, Your Honor, thank you.
All right, Mr. Payne, you should be all set. Thank you for your appearance today.
Don't leave yet.
Oh, we're going to get you a notice,
I got it.
so you have one in hand. No line through
Yesterday,
it.
we had the giant black line. going
Yes,
down
I
one
remember.
Maybe it rested overnight. Decided not to do.
There's a Lee Brandis in here. Is that for you?
Where's Mr. Brandis?
No.
Oh, just the paper.
All right. Oh, just the paper.
He
Okay.
got it, cause I saw.
All right.
Are you ready on Mr. Rogers?
I thought this was canceled. My understanding was that we have a review hearing set for July 9th.
Okay.
This was set before we received the report. And so when we came into the report,
Right.
we set it for July 9th, and I thought we canceled this date.
All right. Let's check to make sure it's set on July 9th, and then
Which one?
it's Jonathan Allred.
No, Rogers.
Rogers. Oh, Robert Rogers.
Just got paperwork to be here on the 29th.
All right.
So
Yes.
from the judge
Yep.
last time I was here in court on the 4th.
Yep.
I have it set on the ROA for July 6th at 1:30. Is that?
That's probably it. Let me check. Yes, July 6th, 1:30.
Your Honor, can I do a motion for you real quick? Judge Tremblay has my competency paperwork from Judge Fleece and Judge Alderson. Judge Alderson got me out of forensics when they illegally arrested me and said I wasn't competent. And she goes, "You are competent." And she got me out within 24 hours. That's a misconduct charge right there. And I do have that. You can get a hold of Mrs. Tremblay on it. It's on her desk. And I already talked to her about the doctor showing up at the hospital over there.
Okay.
That's a federal felony when he's got a stalking charge. He can't stalk me.
Yeah, I don't know anything about that.
I
just
do
know
have a
you-
new police report on that, and you asked her last time to follow through on the police report with the camera footage at the hospital, and I haven't been able to talk to her since we were here last.
All right.
She has not contacted me back at all. And I talked to her investigator, and I have a live video charged and recorded with them on the competency.
Oh, yeah.
So somebody took my competency paperwork, and you can see where they whited out the competency and put incompetent on it, and the top of the paper says competency paperwork.
All
That
right.
means I'm competent. So you might want to get with Judge Tremblay on that. On my
All right,
case.
I'll talk to well, I don't know if
You might want to, because she has the paperwork and she says, "I'll get with Judge Flores," and I have not heard from her. I talked to her secretary the other day on this.
All
So you
right.
might want to just confirm on those two things, issues together.
All
That's
right.
stalking me when a guy's got a stalking charge on me. That's weird. Well, how did he, and who, there's HIPAA violations. If anybody at that hospital called him and told him to show up there when I was at the hospital, that's HIPAA. And you know that, those are $10 million. So you might want to look into that part of it. And I'm being honest with you and truthful, and I'll work with you guys anyway in the truth to tell you the honest truth of this. And I have evidence of it.
All right. I have not heard from Judge Tremblay, but I'll wait to hear from her.
Yeah, but of course we have, the court has noticed that we have a court date set. for July
Absolutely.
6th.
And there is
Waiting.
competency there in her office. You might want to check with that in circuit
Do
court.
we have that in the computer? It's set for July 6th at 1:30?
Yeah.
I just want to make
Okay.
sure when
So
we
I
get,
think
we come here, we're all
I think
here.
we're set, yeah.
All right. So we're on the record in 2503-484. We've confirmed that this hearing has been moved to, and I think it's to the competency review hearing for July 6th at 1:30.
Yes.
Okay.
All right. Ms. Donnelly, you can indicate your presence for the record.
It's our Assistant Public Defender, Sarah Donnelly, for the defendant who's
All right.
present.
And Ms. Fortuna, go.
Yes, Your Honor. Haley Fortuna Gill on behalf of the people.
And sir, you are Robert Rogers.
Yes, I
correct?
am, Your Honor.
All right.
And I am presenting myself, and I did talk to Mr. O'Keefe this morning, and he will step in on this case, and I just talked to Mr. Anderson on it too.
All right, perfect. We will set it for July 6th at 1:30. We're.
Can I get a printout on that? Because I keep those documents. I give them all to the judge in circuit court.
Yeah,
It's got
we're
all
gonna-
my paperwork.
We're gonna do we're gonna print out a notice and then you can give it to the judge of circuit court.
Thank you.
All
very
right,
much.
so it'll be set for July 6th at 1:30. I'll see everybody then. Thank you for your appearance today.
Thank you. You have a beautiful day, Your Honor.
You too. And then you'll get your notice from Ms. Donnelly.
Thank you. And I don't have a problem working with the attorney here, but I just feel that there was misconduct done in the last time I was in court with Judge Alderson. And I wanted to bring that up. That's a federal felony.
Okay.
Old fire alarm.
All right,
Thank you.
that's Mr. Rogers.
If you want
Because Ms. Donnelly is up for sainthood.
Open the door.
record, but he was present. He had a bit of an emergency.
All right. So Mr. Wicks, we'll call your case. So we're on the record in docket 26011370. That is People of the State of Michigan versus Kane Wicks. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Wicks, who's appearing over Zoom.
And sir, you are Kane Wicks, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Wicks?
Yes, I can.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, we're asking the exam be left set on. There is no offer at this time. I do not anticipate there will be one.
All right, and that's a fair statement, Ms. Robinson.
It is, Your
All
Honor.
right. We'll set it for the previously scheduled prelim for June 5th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. I'll see everybody on Friday, June 5th at 8:30. Anything else for the record in 26011370, Ms. Fortuna Gill?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Wicks, we'll see you live in person. Zoom would be inappropriate, so live in person at 8:30 on the 6th floor of City Hall of Lansing. All right, sir?
Okay, thank you.
Thank you. We're all set there.
And then before we call a Laird, I just want to confirm, is there anybody in the waiting room? I got an email from my office that
We have-
complaining witness might join.
We do have somebody from the hearings from DOC, it looks like.
Okay, but no,
I don't have anybody
okay.
from hearing. That was the only person in the waiting room.
Okay, then we are ready on a Laird.
Let me find out who that is. I just let you in the courtroom, on the Zoom courtroom. Sir, could you please identify yourself?
My name is Jonathan Allard.
All right, we're going to call your case next, Mr. Allred.
Yes, sir.
From the Department of Corrections or from the hearing room, what's your name?
Tony O'Regan.
Spell your last name and we'll try to figure out what docket you're on.
Heredia.
Heredia. Heredia.
Oh, that is a case we have, but it's not. It was scheduled, but it looks like it got rescheduled.
What was it rescheduled for?
It looks like June 29th. It looks like it was just a computer error at some point.
All right. What was it scheduled for? Probable cause conference or a
It's a sentencing on June 29th, 2026 at 1:30 p.m. is what my system says, and it's wrong sometimes. So
I'm pulling it up.
We'll confirm the two computer systems and see what that has. Mr. Harriet, your sentencing date has been reset. It's not on our docket. I'm going to give you a date and time once we can confirm it, but you're not going to be sentenced today.
Your Honor, I have a parole hearing date on the 29th.
Right, you have a sentencing date. It is a sentencing date. You have it as a what kind of hearing do you have it for?
For parole. I'll be going for the parole board.
Yeah, I don't work for the parole board. This is a sentencing in the city of Lansing.
Okay, all right.
Yeah. But let me see. Obviously, we've got some miscommunication here, but let me see what we have it rescheduled for.
We have a couple of things. So we have, it was removed from the calendar for today.
Okay.
It is scheduled for sentencing June 26th at 10 / report information, sentencing. And then it's scheduled for a review on 6/12. I don't know
That doesn't make any sense.
Then it was removed from the calendar on 6/26, and now it says 6/29.
Okay,
So. let me
so
look.
I
I
think we've
see
just
that.
matched the June 29th at 1:30.
That is the match, I think, because my
Okay.
system also has the 6/26 date, but then it's grayed out.
Yeah, so,
All right.
and it's not on our docket on that day, but let me look on that other one. What was the 12th?
So is
You said the
is it
12th,
set for June 29th at 1:30 on our docket?
I believe. Yes.
All right. So, Mr. Heredia, we have you on June 29th at 1:30 set for sentencing. I don't know how that affects your parole board status, or that's a different parole board review. But we've got it set for June 29th at 1:30. All right, sir?
Yes, sir.
All right.
So should I take, he was scheduled on the 12th also for a review. Should I take that off?
I would,
Nation might have scheduled that to meet with them.
yeah, don't.
Oh, yeah, you're right.
Just to meet before. All right.
Yeah, you're totally right.
All right, so we'll see you on June 29th at 1:30. You should be all set, sir.
Yeah.
All right, Mr. Allred, we'll call your case. So we're on the record in docket 26-01403. That's People of the State of Michigan versus Jonathan Allred. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Allred.
And sir, you are Jonathan Allred?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Allred?
Yes, sir.
All right, this is the time set for a preliminary probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. At this time, we're asking that the matter be left set for preliminary examination. An offer was extended to plead to a misdemeanor aggravated domestic violence with the sentencing agreement to 7694A. That offer will remain open until the beginning of the preliminary exam next week.
And is that a fair statement, Ms. Robinson?
It is, Your Honor. Thank you.
All right. So we've left on for prelim for June 5th at 9 a.m. That'll be live in person on the 6th floor of City Hall of Lansing. So next Friday at 9 o'clock. Anything else for the record in 26-01403, Ms. Fortuna Gill?
Not for the people.
Ms. Robinson.
No, Your Honor. Thank you.
All right, Mr. Allred, we'll see you next Friday at 9 o'clock. Thank you for your appearance today.
Yes, sir. Thanks, sir. Have a nice day. Am I able to leave, sir?
You are. Thank you for your appearance.
Yes, sir. Thank you. Bye-bye.
And then I think we have that's it for Mr. and then Mr. Murphy.
Yes, so I will go see what's going on.
See if they're, 'cause, yeah, I didn't know it was gonna go this fast, but it
Me
went,
either.
yeah, it went pretty fast.
Have a good weekend.
You too.
Thank you, Ms. Robinson.
Yes.
Enjoy the nice weather. We're supposed to have good weather, I think.
Fingers crossed.
Yeah, so see where we stand with Mohammed Murphy and
I will get to the bottom of it and let you know.
I
All
just messaged Addie.
Okay.
and I don't know, but that it was set for 9:30, so your witnesses.
Yes, they should be here or arriving.
Yeah, I don't have anybody in the waiting room either.
I do not anticipate their appearance.
That they're okay.
But I have been surprised many times.
All right,
so-
come and get me when you're ready.
Okay, thank you, Your Honor.
You're welcome.
Figure out where all these go.
I like PCC Day. It goes pretty quickly.
And I'm ready. Tell the plan, come get me, man. No more hot doors.
They gonna drop me off at the road. Yeah, they probably drop you off out there. If you got it. Done. You got at least order it up. Yeah.
I'm getting ready to so one.
Court officer, if we need to type. Could we have Murphy brought up and we can speak to briefly, and then I believe we would be ready to go on that.
Did they do the prelim over there?
Well. Goodrich was over in Buchanan handling something and he's talking to somebody else.
Yeah, I know you're.
Oh, okay.
Maybe.
Addie just messaged, she said, not sure. I said, is the prelim going? She says, not sure. We haven't even made it that far yet. So we actually finished before they did.
Yeah.
Okay, so you
So
want
my-
me,
Yeah, if we could have him just brought up and like put in the jury box for me to speak with briefly, or put here for me to speak with briefly.
well,
I
we're
think
done.
we'll
So
have
he's
a-
literally the only thing we have
Yeah, I
left.
think we'll have a resolution.
Okay. So let me go get DK.
It
He's
sounds-
downstairs?
Yeah, it sounds like the
That's right.
assaultive case is probably gonna get dismissed, and then I think there's a pretty reasonable resolution if he's willing to accept on the other case.
Be nice to Matt. Best of luck.
Yeah.
Read resolution. Drop all charges.
So give me this right, man, you know how I get. I'm sorry. Man, you know I get tweaking you, bitch. You know, you know, you know. No, you see. If you see me, come get me. Man, they about to make me miss my damn show.
And then I'll just leave when he gets up here so you guys can talk.
Y'all can treat me as new ID while you at it. Y'all lost it. I ain't paying for that. Y'all paying for that. That's $5.
2.5 bags of chips, man. There's 2 phone calls. What you looking at all crazy and shit for? Well, oh shit, here comes your boyfriend, Randy.
As we know. As you know. But, that's how it looks like.
So. Let's.
Yeah, I got this breakout on my chest, stupid. It's like, oh no, it's like a rash or something. Cause that's it. I didn't hear that today.
There's a. No, no. Yeah, right.
That's being lost. So they got fucking on it. I do not think we're doing it. I'm probably got. Seven. Any part,
The two. Yeah, not here, two, what? Maybe. That's over county holding day. You know what I'm saying? And the line, the schedule, it doesn't have everything the same. Here, if you call it in second, now, that like. All being the day, Sunday. I didn't email, stick my heads up, trying to email it, so that way they, so. When they lose their, they show minimum covenant spreadsheet there, so they should. And will show their family what's the fall. Okay. Yeah, but. Yeah. So, okay, before next door, we. No. Yeah, from top. Okay,
Only was on Flores, that's all much get lost in. Yeah. Take a break. Thank you.
It's not the horse I'm sitting back. That's sitting.
Oh, that could be. You know, I did, yes. Three. Got the arm. Three. They tell you what the third. Good. Good. You didn't know what four. Looks like they're all. Say not.
So do we have a representative of Gateway Financial?
Yes, Attorney Zach Schisler appearing on behalf of Gateway.
Okay, all right, Mr. Schisler, I've got you in here. And is there a Samuel King?
Yes, sir.
All right. All right, let's call that case. So we're on the record in docket 25-06303. That is Gateway Financial Solutions versus Samuel King. Appearances for the record, Mr. Schisler.
Yes, good morning, good afternoon, Your Honor. Zachary Schisler, P number 82247, appearing on behalf of Adam Kanaszewski and Gateway Financial.
All right, and sir, you are Samuel King?
That's correct.
All right, thank you. All right, this is the time set for a motion to set aside the judgment. First thing I'll do, if the parties had the opportunity to discuss this case prior to hearing the motion, I don't know if you've had, I can place you in a breakout room, or if you want to go forward with the motion, that's fine also. I believe this is set aside judgment motion. So let's see, comes out of so there must have been a default on this. Is that correct, Mr. Schisler?
Yes, Your Honor.
Okay. So this is your motion, Mr. King. Did you want to meet with a representative of Gateway Financial concerning this matter? Or did you want to go forward with your motion?
If we can reach good terms, then we can meet in privately. We have previously spoken about a settlement for this matter, but we have not settled on like other points of the matter as far as interest.
So I'll ask you again, do you want to meet with Gateway Financial, or would you like to just go forward with your motion?
We could just go forward.
All right. You may proceed, Mr. King.
Okay. Give me a second. So it says the docket shows plaintiff, they filed the affidavit of attempted service. Then they asked for alternate substituted service. Alternate service was apparently done by posting at a mailing address of 911 North Walnut Street. I did not live at that location, and I didn't receive the proper papers or actual
Have you
notice.
previously lived at that location?
I've never lived at that location.
All right. And so you've never lived at 911. Did you ever use that as a mailing address?
I don't believe I use that as a mailing address, but when I have been in town visiting Michigan, I have slept there.
So you don't believe you've ever used that. So how would Mr. Schisler know to use that as a posting service?
I'm not exactly sure on
then he's just kind of guessing where you're at. Did you leave your last updated address? Did you update your address as you went along?
No, I actually didn't have the power of attorney to do any kind of like legal paperwork or.
But you just have to contact the post office to update your last address.
Yes. During that time where this service was being attempted, I was in a medical crisis, and I didn't have the ability to handle any of that, anything. You know, I was actually being taken care of, and I was living out of state.
All right. So you're indicating you didn't get notice of the hearing. That's why you're defaulted, because you were in medical crisis.
That's correct.
All right. And so what is a current good address to locate you at?
So my current good address is 300 Western Avenue, apartment B323, I believe. Let me get that exact.
What apartment number there?
It's apartment C234, 300 Western Avenue, apartment C, as in cat, 234.
And that is in what's your location?
Lansing, Michigan.
And your zip code?
48906.
Okay, 48906. So your response is you weren't served properly at your address. You didn't have notice of this, and then you were going through a medical crisis. Is that correct?
That's correct.
All right, Mr. Schisler, response.
Yeah, Your Honor, it looks like, based on my reading of this file, the address was reported from the employer, which is where the valid garnishment that's currently in effect is in place. And so they would have reflected that address back to us when they gave us the positive hit for employment. But nonetheless, Your Honor, in order to set aside a default judgment in the state of Michigan, you have to have both good faith and a meritorious defense. Everything brought up by Mr. King, relates to the first part of that, but nothing to the meritorious defense. There was no affidavit filed in support of his motion, detailing the reasons why a trial would be needed. And so, I have reason to doubt that the address was inaccurate, but I'm very satisfied or would make the point to the court that, he hasn't even addressed the second prong of that requirement.
And that's fair. Mr. King, do you have any defense or valid defense to this case? And that's why you probably should meet with Mr. Schisler rather than put it on the record. This is all recorded concerning any valid defense because it's a two-pronged test. The one prong is that a good faith effort that you were served, and you've pretty much hit that, but I don't know of your meritorious defense.
Okay, we can definitely meet in private.
All right, Mr. Schisler, would you be amenable to meeting with Mr. King in a breakout room?
Yes.
All right, I'm going to indicate that all parties appeared. And to meet in a breakout room. I'll also indicate that some of the motion was started and then we went to breakout room. All right, so I'm going to add that note, and Mr. Schisler, I'm going to place you in room 1 along with Mr. King. I'm going to place you in room 1, and then we'll come back and put it on the record. So Mr. Schisler, you'll get a prompt to go to room 1, and Mr. King, you'll get also a prompt to go to room 1.
Okay.
And we have Maria Williams and Marvell Williams. You can come up here, and then Mr. Akanicki, you're here for Seal Group 3?
Yes, Your Honor.
All right. And this is set for pre-trial today. So we're on the record. You can have a seat. We're on the record in docket 2601095R. That is Mariah Williams and Marvell Williams versus Seal Group 3 LLC. Appearances for the record. Sir, you are Mariah Williams?
I'm Marvell Williams.
Marvell Williams. And you are Mariah Williams. All right. Thank you. And Mr. Akanicki, your appearance for the record.
Good afternoon, Your Honor. Robert Akanicki, attorney for the defendant.
All right. This time is set for a pretrial in the matter. As in all cases, I'll give the opportunity to have the parties meet to discuss any issues that led to the coming of the pretrial. I can do that by placing you on an iPad, and then you can have some privacy time with Mr. Akanicki to see if you can work anything out. We can always fill out a pretrial statement as we did in, I think, 2 cases ago.
Okay.
Mr. Williams and Ms. Williams, do you have a preference as how you'd like to proceed today?
Proceed.
So do you just want to fill out the pretrial statement?
I mean, I'm open to speaking with him if he wants.
Okay, Mr. Akanicki, would you be amenable to speaking with the Williams in a breakout room?
Oh, yeah, no problem.
All right. So I'm going to indicate all parties appeared. And to meet in a breakout room. So we're going to get the iPad because we usually have it for landlord-tenant day. And if you follow my court officer, she'll place you on the iPad. She'll give you a room for some privacy. You can talk to Mr. Akanicki, and then you'll come back. We'll put it on the record. Okay.
Thank
All
you.
right. You're welcome. And I'll add the iPad to the room when it becomes part.
Okay.
All right. So Mr. Akanicki, you'll get a prompt to go to room 2, and then we'll place the iPad in there in a few minutes. All right, Mr. Garlinghouse, you're here for 3S Fund 1, is that correct?
Yes, Your Honor.
And is Larry Weaver here? All right. All right, so we're on the record in 26-01095. I'm going to add this iPad, and then I'm going to put it in the room. That'd be assigned to 2. There we go. All right, so we're on the record in 26-01095. 26-01095. Oh, that's the last one. 63. 2163.
26-021.
Yeah. So we're on the record in 26-02163. That is 3S Fund 1 LLC versus Larry Weaver. Appearances for the record, Mr. Garlinghouse.
Yes, good afternoon, Your Honor. Nicholas Garlinghouse, appearing on behalf of Plaintiff's Counsel of Record.
And sir, you are Larry Weaver, is that correct?
Yes, Your Honor.
All right, thank you. All right, this is time set for a motion on the matter. I'm assuming it's a motion to set aside. And this was based on a conditional dismissal, is that correct, Mr. Garlinghouse?
Yes, Your Honor.
All right. So Mr. Weaver, you wanted to place the dismissal aside.
Yes, Your Honor.
All right. And you filed a motion to that effect. That's the motion set aside.
Yes, Your Honor.
All right. And I'm assuming you've had the opportunity to speak to Mr. Garlinghouse.
I have not spoken with Mr. Weaver.
Did you want to speak to Ms.?
My client just wants us to move forward.
All right. All right. All right. So Mr. Weaver, you may proceed with the motion.
Okay. Well, first and foremost, Your Honor, I live in a lease, so I've been living
So there's 2 prongs for a motion to set aside. One is that for some reason you did not sign the conditional dismissal.
Okay.
And the second is that you have a meritorious claim. Those are the 2 to set aside the conditional dismissal. I know I put every conditional dismissal on the record, and I indicate that I make sure that you sign the bottom of it. I put it on the record, so I know that's not an issue here. You wanted me to sign the conditional dismissal, and I did sign the conditional dismissal. So that prong's problematic for you. Okay. The second prong, you can go ahead with your motion.
Well, I didn't know my rights at the time when I signed.
And that's what we do put on the record, that you have 3 days from the date that you sign it to indicate that something we did here was vague or ambiguous.
Right. So like after I didn't understand exactly what I was signing, but I did seek legal assistance, and I was able to contact an attorney, and they walked me through everything and broke it down where I could understand exactly what happened. And
how many days after that did you meet with the lawyer?
Actually, that Friday, we signed it on
Wednesday.
Yeah.
Tuesday or Wednesday, I would think. Okay, and then when did you file a motion that this was vague or ambiguous to you?
After I spoke with the Monday.
The following Monday, you filed the motion. Right, and let me see if I have the motion. Let's see. So I have you signed, and you're personally, and the MCR is written. That was on May 6th. And your indication is you filed the motion on May 11th. Is that correct? Because May 6th was the Wednesday, and that would put you within the 3 days, May 7th, May 8th. And then we'll give you the week of 9th and 10th because we're kind of closed. So May 11th. So the indication is your indication is you filed the motion on May 11th. All right. And this was the second time you've met. You, all parties appeared, met in a breakout room on April 22nd, and then you met again on May 6th. Is that a fair statement?
Yes.
Okay. All right, so, and the second aspect is a meritorious claim that would go into the litigation of this. I would assume that's why we were here, was you had some disputes concerning what was the part of the ledger or things of that nature. That's why we had a landlord-tenant hearing. Is that a fair statement?
Yes.
Okay. All right. Response, Mr. Garlinghouse.
Well, Your Honor, I have a few things, I guess, to respond on this one. The motion says that he did not know his rights or misunderstood them, and that plaintiff never explained the rights to him. I would dispute that and find that not credible, because not only was he advised of his rights at the pretrial, I did speak with him personally before we signed the conditional dismissal and presented it to the court, and explained the rights at that time, the right to a trial, the right to seek an attorney, so forth, and the right to make a motion to set it aside if he didn't understand. And then the court also on the record confirmed that he understood his rights and put that on the record before accepting the conditional dismissal. So that, I believe his motion fails on that. And then the motion mentions something about the Vision property lawsuit that he was part of, a claimant in. And that lawsuit was settled back in 2024. And the tenants in those cases had until February 28th of 2025 to either accept cash for keys. This is from federal district court, to either accept cash for keys or to sign a lease at that time. Neither of those rights were exercised by the end of February 28th, 2025. The property was sold after that to my client, the current client, 3S Fund, and it's been month to month all along, and was terminated. It was a termination of tenancy case. It's not a non-payment case. They filed the notice to quit 30 days, and everything has been, I don't believe there's any defense that's been raised that would negate the notice to quit in this case. So both the meritorious defense and reasonable cause or lack, the fulfillment of the court rule not understanding rights, I believe, are not fail in this case, Your Honor.
All right. So I agree with Mr. Garlinghouse has indicated, except for he did file on May 11th. It looks like May 11th, 2026, requesting a hearing date and trial, did not know my rights or misunderstood them. They have not communicated with me. That's involved in Vision property lawsuit. You said that that's not a meritorious claim. Right. And plaintiff never explained rights to avoid eviction process, but it appears that he filed the motion and null and voids whatever was done on the conditional dismissal. Since we're not in that date, I would expect that we just set this for formal hearing.
Your Honor, he did file on time,
yes,
but he has to show that he misunderstood his rights or was not advised.
And that's what he's indicated today.
And
yeah, that what he said is that he didn't know the nature of what he was getting into, and I could find that credible or not credible, right. But my response is that we just set it for hearing and go from there.
Your Honor, I guess I understand, but I also would dispute, because he said today that he wanted you to sign it on that day as well.
Yeah, he did. There's no doubt. This is the reason why we place it all on the record. We place it all on the record so everybody's here, and you have 3 days from today's date. You filed within 3 days. I mean, you filed on the last date. So you are indicating that something we did was vague or ambiguous, and you've testified to that. So with that uncertainty, Your Honor, my response. Go ahead, Mr.
Sorry, Your Honor. I do apologize for interrupting. I guess I'm still unclear as to what right he didn't understand, because that has not been indicated in any way. He's got what he's claiming is a defense then, but again, it's not a valid defense. But he was unclear as to his ability to bring that, but not as to his rights to waive representation or to have a
Yeah,
trial on the matter.
so what
right.
didn't you understand about what we did on that date?
I really didn't know exactly what I was signing. I never got information. I actually never communicated with his company at all.
But he is a legal representative of his company.
Correct. Like I spoke with them one time, once they maintained possession of the property, they offered me a lease and it's right here. We just can't come to terms. The property's not up to code. I said I would sign the lease with them.
But that lease has nothing to do with the complaint that was filed.
Gotcha.
Yeah, the complaint that was filed, and I can look it up, but the original complaint.
Yeah, the company never explained to me.
Was filed in.
Never explained to me my rights.
March.
Yeah.
Yeah. So the original complaint was filed in March. You've now come and said that what we did in May was you don't understand it. And my response right now is, okay, let's set it for hearing.
And that's why I sought legal assistance.
But we can set it for hearing pretty quickly.
Okay.
Yeah, that's just the turnaround on this would be just to make sure that if you have any witnesses or ledger that you need to subpoena, and then Mr. Weaver, you'd have to be here, but I think we could probably set it in a couple weeks, if not sooner.
Yeah, that would be good. The sooner the better on the hearing if that's what we're.
Yeah, so let's set so you have filed a timely disagreement, and I'm not gonna and within the 3-day time period, so we'll respect that. You've indicated you didn't know what you did there. You did that by May 11th, but we'll set it for today's the 20th, so we can we set it? I don't know. I know that we're busy on the 17th. How's the 10th look? That may interfere with your ability to get witnesses here.
I think the sooner the better.
All right. How does that 10th
Are we
look?
talking for a hearing?
Yeah, full hearing.
I already have 9 hearings on that day.
Now we have, let's make it 10. So we'll do May 10th.
Wait, May, no, we can't do May 10th.
I'm sorry, June 10th. Did I say May?
Yes. At 3.
All right, let's try that. Let's do. Yeah, and that way, because this has been going on for some time. It's been going on since March. This would be, yeah, this is so it's 2602-163. It's yeah, just a regular. It's
termination.
Is this a termination of tenancy or is it okay? All right.
Yeah, based on a month-to-month lease.
Yeah. All right. So based on a month-to-month lease, it's a termination of tenancy, and we'll set it for June 10th. June 10th at 3 o'clock. So that'll be a live hearing, okay, and in front of this court. I'll make a decision on the merits of the case. You should bring in any evidence you want the court to consider, okay? Any evidence must be tangible, so it must be able to be marked. So I can't see anything on a cell phone or video, and it has to do with this case. It can't be with another case, it has to be on this case when this complaint was filed, okay? Bring in any evidence, and then we'll go from there. That is June 10th at 3 o'clock, okay, sir? All right, so I'm gonna grant your motion to admit. I'll grant your motion to set aside, and we'll set it for June 10th.
Thank you, Your Honor.
Thank you, Mr. Garlinghouse. You should be all set, sir. So, and I guess we'll hold because I want to wait for an order, but it's a week. So, yeah. So so we'll just hold on. I'm granting your motion to set aside because we're setting it for a hearing. But I'm gonna take it under advisement, just so you don't have to file an order within a week, okay? Because you'd have to file an order setting aside the verdict, and I'm just gonna put in there, place in abeyance, so you'll be here next Wednesday, okay? All right. All right, I'll see everybody next Wednesday. It's June 10th.
2 weeks, I believe, Your Honor.
Yeah, 2 weeks. June 10th, is that right? June 10th at 3 o'clock. You're all set. Thank you.
Have a good day, Your Honor.
You too. That's gonna be a busy afternoon.
Need a break.
All right, so we're on the record in 25-06303. That is Gateway Financial versus Samuel King. And Mr. Schisler, did you have the opportunity to speak with Mr. King in a breakout room?
I did, Your Honor, and we were able to come to an agreement under which
All right.
Mr. King would withdraw his motion to set aside the default judgment, and the plaintiff would agree to reduce the garnishment that is currently in place with his employer to a maximum of $200 per pay period coming out of that garnishment. I have, we previously sent that agreement over to him, but he's not able to access it, and so I'm going to have the attorney of record resend that over to him. I believe it just has the reduction language in it, so if he could just place his withdrawal of the motion on the record, would that suffice for that issue?
All right, so Mr. King, you are withdrawing your motion to set aside the verdict. Is that to set aside the order? Is that correct?
That's correct.
All right, and then Mr. Schisler's indicated that you've come to an agreement, and that agreement is going to be sent to you sent to you, and then you're going to review the agreement and then send it back for the court signature. Is that how it's going to work, Mr. Schisler?
Yes.
Okay. All right, so the agreement to be sent to all right, so the agreement is to be sent to Mr. King, and then after he reviews it and he signs it, it'll go back to Mr. Schisler, and Mr. Schisler, you'll present to the court?
That's correct.
All right. All right, so consent agreement, the terms have been placed on the record, and I will sign the order when it comes to me. Can you think of anything else for the record in 25-06303, Mr. Schisler?
I've got nothing further, Your Honor.
All right, Mr. King, do you have any questions of me?
No questions, but one thing can I say, if he's able to answer this, will the amount of what's due and what's paid be reported to the credit bureaus as they're being paid, or will they be?
Yeah, we'll continue to. Gateway does that themselves, so these payments are all remitted to Gateway directly, and they still, comply with all laws about reporting it to credit agencies. So that doesn't matter whether it's pre-judgment, post-judgment; they're still reporting the payments.
Okay, no more questions.
All right, so the agreement would indicate how much is to be garnished, and then Mr. King, you're agreeing to it, and you'll sign it and send it back to Mr. Schisler.
That's correct.
All right, I will await to sign the order. That's all for the record in 25-06303. Thank you, Mr. Schisler and Mr. King, for your appearance.
Thank you.
Thank you.
All right, Mr. Aknicki, you've had the opportunity to speak with Mariah Williams and Marvell Williams in a breakout room.
I have, Your Honor. We weren't really able to come to any substantive resolution, but we have a pretrial statement all filled out that I can go over with the court briefly.
All right, you can place any pretrial statement on the record.
Yeah, so I just want to put all the terms on the record so the plaintiff knew what I was filing with the court because they gave me permission to sign, and that is there was a pretrial held on May 29th, appearing in pro per for the plaintiff, and I was for the defendant. The issues are plaintiff is alleging inhabitability issues, damage to personal property, storage of personal property, and constructive eviction. Defendant has a potential counterclaim for unpaid rent. Plaintiff's pleadings are in order. Defendant reserves right to file a counterclaim within 14 days. Motions, there could potential motion for summary disposition that would be heard by August 29th, 2026. No need to consolidate with any other cases. Admission of fact, parties admit that there was a lease in place and plaintiff no longer resides at the premises. The exhibits would include a lease, a ledger, text messages, pictures, city inspection reports, etc. We have discovery with a 60-day cutoff for July 29th, 2026. No expert witnesses. Damages. Plaintiff alleged damages include damage to personal property and alternative housing. Defendant's alleged damages are unpaid rent and damage to property. No joinder of claims. It would be a bench trial. No more than a half a day set after September 29th, 2026. And possibility of settlement is possible. We didn't see the need for case evaluation or for mediation. And I signed with permission for them and signed for myself, and I can submit on my file.
All right. And did everything that Mr. Aknicki placed on the record, was that a part of the pretrial statement?
Yes.
Okay. And you provide permission for Mr. Aknicki to sign on your behalf to advance to the court for the court signature?
Yes, Your Honor.
All right. All right. So Mr. Aknicki, you can provide that. You've been given permission, authorization, or it's on the record that you may sign on their behalf to advance to the court. And then it'll probably be scheduled for a bench trial if once motions are set, they'll be scheduled for bench trial by the civil department.
Okay.
Is that a fair statement, Mr. Aknicki?
Yes, Your Honor. Thank you.
Okay. Anything else for the record in docket 26011095, Mr. Aknicki?
No, Your Honor. Thank you.
Either of the Williams, do you have any questions of me?
No, we're good, Your Honor.
All right. You can get a copy of my signed copy from our civil department. Okay. All right. All right. You should be all set. Thank you for your appearance today. You're all set, Mr. Aknicki.
Thank you, Your Honor.
Is that it?
I think that's it. Let's see. I think based on the record. Order. Oh. All right. I'm gonna remove that because I don't think
I think that was from this morning.
I think we still have the jail here and I don't know why. All right. So that's 5R. Oh.
Signing off.
And then we did.
Star, are you gonna go?
I don't.
Really?
Case.
Oh.
We just set that for hearing, right? We set. Motion set aside. We set for June 10th. At 3 o'clock. At 3 o'clock. And that may go. But we'll
Upload it.
I have a feeling that's not gonna go, or if it goes, it's gonna be pretty quick.
Do you think those two are together? They kind of sat apart.
Yeah, that's an interesting statement because I initially did, and then he left and she didn't. She left with the two that just left,
Oh,
with the Williams. So maybe she was with them. I don't know. That is an interesting question. All right.